Good evening, viewers. Welcome to another edition of Legal Hour. My name is MC Chaka. I'm your host for this very insightful and educative program that we bring to you every Thursday and Tuesdays from 8:30 onwards. Legal Hour is where we discuss legal matters, and of course with our sponsors from City Law Solicitors. City Law Solicitors, they've been our backbone from day one. And this program is very educative. We talk about all areas or aspects of law, immigration, employment, all legal aspect, name it, call it. So tonight we're here to discuss a very important topic, which is immigration matter. Tonight's topic is, can a non-biological parent qualify for leave to remain after 7 years of child's resident or British EU child with pre-settled status? It's very educative. We all know the causes, the issues that the Brexit have brought onto people, especially people from Africa, to regularize their stay in the country. So this is a very new area that lawyers and people from City Law have been able to come up with. So tonight, I'll be here with my usual guest lawyer, Thomas Beyebenwo, to discuss aspects or areas that people can regularize their stay on this matter. So please make sure that you invite your friends, you share this program, and make sure that you get everybody on board. This program is live on our Facebook channel. If you check on Solicitor Thomas Beyebenwo or the YouTube channel Solicitor Thomas Beyebenwo, and it's also live on our radio channel, that is City Media Radio. If you go to Modern Ghana, of course, the abroad section, City Media is right there with the abroad radio online. So please make sure you share this program. I'll be very much happy to introduce my guest for this program, which is lawyer Thomas Beyebenwo. But before I do so, I'll take a quick commercial break, and when I come back, I will introduce lawyer. So please stay tuned. Don't go away. Wait for me. I'll be back. Thank you very much. Viewers, welcome back. Lawyer is just getting ready. So we're going to start very soon. And I believe our viewers are very keen to know what is going to happen tonight. I was just on the radio. I came back, obviously, to let people know that we're going to be on TV. So tonight, we've got a very interesting topic. Make sure that you share this program for all your family, all your friends, everyone that you know, to benefit from this very important and educative program. City Law Solicitors, they've been our backbone from day one. And tonight's program, they are sponsoring this program. They are sponsoring. My name is MC Chaka. I've been your host from day one. This is very insightful, very educative legal program that we bring to you every Tuesdays, Thursdays. So please make sure you share this program for your friends, your family to benefit from this program. So I've got Lawyer in the studio. I'm going to welcome him very soon, viewers. So make sure you share this program. As I always say, we're live on City Media Radio. This radio is powered through Modern Ghana. And of course, we've got our Facebook live program as well. So we are here tonight. I'm here with Lawyer Thomas Beyebenwo from City Law Solicitors. Lawyer, I've got you live on the studio. Lawyer, thank you very much for coming and welcome to the program.
Thank you.
How are you doing today?
Very well, thank you.
You're looking very smart as always. Good. Viewers are really pleased. I've got a lot of messages from people recommending you for this generous program that you've been doing all the time, dedicating your time and impacting your knowledge on people. Thank you very much, and I must commend you once again for attending this program.
Thank you.
Anyway, so tonight's topic is very educative, very insightful. Before we start, or before I crack on with the topics, let me just give you the opportunity to introduce yourself. Just yourself and your firm. Please do me the honor and introduce yourself.
Hello, everyone. Thank you so much for always being there for us. My name is Thomas. Most of you already know me. It's the first time that you are watching us. We do this program Tuesdays and Thursdays. And I'm from City Law Solicitors. City Law Solicitors, we specialize in numerous areas of law: immigration, family law, personal injury, clinical negligence, commercial disputes, civil litigation, employment law. And above all, we also specialize in consumer law and media and entertainment. So if you ever have any of these problems, don't look far. You can always count on us for ultimate outcome.
All right. Thank you very much, Lawyer. So please don't look far. If you always want to look for the ultimate outcome, City Law, they specialize in all aspects of law. Give them a call, and then of course they will definitely help you resolve your immigration or legal matters. So, Lawyer, tonight's topic is very interesting, and I'm so happy. When I saw it, I was like, wow, this is very educative, this is very interesting, and this will be very helpful. So thank you for your time. But then let me introduce the topic once again and ask you the rationale behind this. The topic is like a question, you know what I mean? Mm-hmm. So, can a biological parent qualify for leave to remain after 7 years of child's resident or British child with pre-settled status? This is very interesting topic. Why this topic? And what came up?
Thank you so much. But this is very distinct area under the immigration rules, and it appears that it has not been explored, but it's clearly provided under the rules. And most times, because people are not familiar of this area, they tend to struggle with so many stuff in terms of regularizing their stay. And if you ask the question, why did I come out with this? Because I know that the EU law has come to an end, even though we are said making applications under the settlement scheme. But our children who are EU nationals who have, for example, pre-settled status, there are children who are British children, there are those who have also lived here for 7 years. And some of them have only one biological parent because the other parent is absent. And there are numerous people who are playing an essential role in the lives of these children. They are not biological parents, but within the immigration rules, these people are entitled to stay on the basis of the fact that they are playing the role of that absent parent, be it a mother or a father. So tonight, we're going to discuss how non-biological parent will be able to regularize their stay by relying on a child who has been here for 7 years, and normally we say a qualifying child, or was brought from abroad and under 18, he has been here for 7 years, or is a British child, born British, or that child is an EU national with a pre-settled status. So what can those people who are playing these roles as non-biological parents do in terms of regularizing their stay by relying on these children? So that is what we are going to discuss today.
Interesting. So this is very interesting topic. Did I say that? Yes, because we're going to know how non-biological parents can apply and regularize or get residence in the UK for a child, 7 years old in the UK. So, lawyer, let me ask you this quickly. We have titles, we got lone parents. So what are the requirements for applying as a parent with a qualifying child for 7 years as a lone parent? What are the requirements?
Yes, it is good that you are starting with the familiar area, or area that almost everyone is familiar with, and eventually will gravitate to the area which is quite distinct. Normally, under the immigration rules, if you look at the immigration rules paragraph 276 AD subsection 1, and if you move forward to subsection IV, you find out that if somebody is a parent and have parental responsibility, or he doesn't live with the child but have direct access in terms of court order, or has any evidence to show that he has parental relationship, then upon this, FM rules can apply where exception EX1 will apply. It means that that lone parent can apply for leave to remain on the basis of the fact that he's relying on the qualifying child. And again, this qualifying child is also defined in the Nationality, Asylum and Immigration Act 2002, where section 117D makes it clear that with that qualifying child, which is either British or a child who has been here for 7 years but under 18, or that child was born here and has been here for more than 7 years, those people are entitled to make applications.
So, lawyer, if I understood you clearly, or to paraphrase what you said, so if the child is not up to 7 years, then obviously the lone parent cannot make the application until the child is 7 years.
Yes, precisely so, because if the child is not, remember that when children are born, if one of the parents have a settled status or is British, then that child is automatically born British. For those whom none of the parents have leave to remain, then that child will not have any leave to remain, and therefore that child needs to live here for 7 years. And when that child lives here for 7 years, then that child is entitled to apply for leave to remain under Article 8 of the Private Life.
Okay, that's fine. Thank you very much for throwing light on the lone parent. So, what about both parents? Because for the same child, because normally we hear that, it's the mother who is eligible to make the application. And sometimes, the fathers might be there without not knowing what they do. So if they are both having that child or living with a child who is been here 7 years, what happens with both parents? Can they both make the application, or can they be eligible to apply for their resident permit?
Yes, this is very fantastic question. Now, the point is that when you look at both parents making application the same time, it does not come under the Appendix FM, but it comes under Gen 1.1, and people that are lawyers will be familiar with that. It means that in those circumstances, those parents need to prove that it will not be in the interest of the child to be removed from the UK. So it's a bit technical. So I'm sure that's why, from the way you ask your question, or you are already familiar that sometimes one parent goes in for the application and then the other one applies later. The reason why people have been doing that, there is legal grounds behind it. And the legal grounds is that normally, if both parents are being removed, and people need to be aware of this fact, if both parents are being removed from the UK, then if the child has been here for 7 years, it diminishes the child grounds for making that application. The reason being that unless those parents can demonstrate that one is not in the interest of that child to be removed, and two, if they are also being removed to their country of nationality, and there are no barriers to that removal, or it's not going to affect them in any way in integrating in that country, then those parents can be safely removed. And obviously, they have the parental responsibility. So if they are being removed, then that child will have no choice other than to follow them. And this is why people who are on limited leave to remain should be careful, because when they have committed offense and they are being removed, they can't say that just because they have a child who has limited leave to remain, they can continue to stay here. They might be removed even though that child has been here for more than 7 years.
Well, that's a fruit for thought. So we all need to learn from this, lawyer. Thank you very much for exploring on that. So what if both parents are from different nationalities? What sort of benefit can be applicable? What can they get from that if they are from different nationalities?
Yes, you see, the purpose of this application, or the grounds that is being relied upon to make such applications, is Article 8, family life or private life. So under the circumstances, if they are from different nationalities, and I think there is a case law which was established, I think about 4 years ago, if the parents are being removed and they are going to different countries, then it becomes a problem, which means that Home Office will be disintegrating that family, which will be a breach of their family life under Article 8 or private life. So normally, it is much stronger grounds for people to make applications jointly when, for example, they are from different nationalities or different countries.
All right, viewers, so this is very important aspect or areas that we all need to consider. The benefit is very great when they are from different nationalities. All right, let me acknowledge my viewers, people watching me right now on Facebook. You guys mean a lot to us. It's because of you guys that we come here every Thursday or Tuesday to bring this program to you. It's very educative, very insightful. If you consult any other solicitor, any lawyer, there's a legal fee, the solicitor's fee you're gonna have to pay before you even get this advice. But this is an opportunity for our viewers that obviously we have to give it to you for free of charge. We do that because you watch us, because you listen to us. Every Thursday from 8:30 p.m., Tuesday 8:30 p.m. We bring you the Tree version, the English version. Tonight is the English version. Usually we used to do that on Tuesdays, but we've moved to Thursday because of changes in our circumstances. So let me acknowledge viewers. Owusu Boateng now show. Yeah, thank you very much, Owusu. We are now here. Owusu Boateng say nice program. We have Nana Frema. Nana Frema is saying, good evening, lawyer. Good evening, MC Chaka. Good evening, Nana Frema. Thank you very much for watching us every time we come here live on Facebook. Karen Asari is watching. Hey, Karen. All right, thank you very much for watching. Nana Owusu every year partisan saying fire, fire. Nana, this is fire. Is going everywhere to quench everything that obviously would be a hindrance to our legalization in this country. Nyamidia Dede. That's Awo Dede. Oh, Miniaba, Awo, thank you very much for watching. Well done, MC Chaka. Well done, MC Nee. Thank you, Awo. We've got Nanapoku Patterson saying big ups, big ups, big ups. Big ups to everyone watching us right now. This program is very insightful. And lawyer, thank you very much for throwing that light into these areas, because a lot of people might not know. They've been living with children who probably are 10, 12 or whatever. They've not actually considered, or they've not had any thought on whether they were applicable to do this application or not. But now you've given us some sort of information. Thank you very much for doing that. Okay, so lawyer, this question is very important. It says, what is the added benefit for both parents if a child born in the UK turns 10 years? Now they've passed the 7 years. They are non-biological parents. Non-biological parents. Or did they have to be biological parents before the 10-year rule can be applicable to them? I mean, can you throw some light in that? It's very confusing in a way, but throw some light into that. Let me.
Yes, so I'm sure most people are familiar with this. But again, when a child is born in the UK, that child is entitled to apply for registration on his or her 10th birthday, and that child can then be granted citizenship under Section 1(4) of the British Nationality Act. And the point is that, obviously, when a child has become a British, then remember I've already explained that even though under the rules, when both parents are applying, the FM makes provisions under Gen 1.10 and Gen 1.11 for both parents to be granted leave outside the immigration rules, but they need to prove those factors that I've already elaborated. But the point is that when that child turns 10 and that child obviously has registered to become a British citizen, then it makes the case even much stronger, because there is no law that allows the removal of a British citizen except those whose nationality has been revoked. So under no circumstances will it be possible for those applications to be refused. So sometimes people who feel that they are not confident of making those applications when the child is 7, their case becomes even much stronger when the child turns 10, especially when they have gotten the British passport for the child.
Okay, that's very interesting. So, viewers, if you've been living with a child and the child turns 7 years in this country and you were unable to make the application, now lawyer is saying your case will be much stronger if the child even turns 10. And with that one, obviously, the case will be easier for Home Office to take into consideration. So please take note. You live with a child, you don't have a stay in this country, maybe your partner don't as well. And obviously, the child is 7 years. You are eligible to make application to get a back passport for the child. And through that, you, the parents, can obviously get your stay or your permit, as we normally say. But then, if let's say it escaped you, or maybe out of ignorance, you did not make that application for your child, and so you're still sort of illegal, when the child is 10 years, lawyer is saying your case will be more stronger. Is that correct?
That's right, because the child will be entitled to apply for registration and then subsequently a British passport. That is
interesting. So now I'm going to move on to people that live, and this is very important, this is very interesting. So this particular question I'm going to ask is applicable to people who are not parents of a child, who are not biological parents of a child. but then they have some sort of contact or responsibilities or relationship with the child. So Laura, this is the question. Can non-biological parents still qualify for leave to remain? And what are the requirements do they need to satisfy? Let me paraphrase this question. If non-biological parents, let's say I live with a girlfriend and I'm not the father of the child, can I, through any means, be qualified for a resident permit, please?
Thank you. But this from the crust of this whole show. When, as I started from the introduction, if a child is born here and has lived here continuously for 7 years, that is when the child, both parents of the child don't have leave to remain, or either the child was born when either of the parents have a settled status or British, that child becomes British, or the child was brought from abroad. Let's say, for example, a single parent migrated from Ghana, Nigeria, Sierra Leone, came into this country. With a younger child, maybe they came on a visit visa. They've been here for about 7 years. The child, when they came in, was under 18, maybe about 10 years. So by the 17th birthday, that child had been here for 7 years, and he's still under 18. Because if you look at the definition of a qualifying child under section 117, you find out that that definition states that either the child has been here continuously for 7 years, the child is born here has been here continuously for 7 years, or the child has been living here continuously for 7 years and the child is under 18, or the child was born British. So that becomes what they call a qualifying child. Now, so if that qualifying child has one parent, in most cases, I deal with cases where a mother will come to me. She has a child who is 7 years old. Child was born here. I normally make those applications for those single parents or lone parents. They get their leave to remain. The child also gets leave to remain. But they might be living with somebody who is their partner. That person, he's not the biological father of that child.
Yeah.
So the question is that how can that particular person, who is not the biological father of that child, or for example, if your girlfriend abandoned the child and left the child in your care, and then you have a new girlfriend who is so enthused about the relationship and is doing everything to cater for that child whose mother has abandoned him or her in your care, then how can that particular person in this situation rely on this child who is not his or her biological child to make an application? Now, I want to take viewers into the law, and then I'll be able to explain why this is possible. If you look at the British, if you look at the Nationality, Immigration and Asylum Act 2002, subsection 117B, subsection C, there is a definition that the public interest normally works for, or when there is no deportation order in place, then anyone who have genuine subsisting relationship with a qualifying child, and I've already defined who a qualifying child is.
Yeah.
So you have a genuine and subsisting relationship with a qualifying child, and then it will not be reasonable to remove this child, then that particular person, under that law, which is the 2002 Act, is entitled to make application. So how do we then define that particular parent? If you look at the case of RK which is upper tribunal case, the case of RK versus the Secretary of State, 2016. And this has been there for a long time. That's why I said people have not explored it. It gives clear definition of those who are non-biological parents who are entitled to make those applications. And those people are what we normally call de facto parents. Okay. Now, that person is de facto parent simply because one of the parents has left, he or she has stepped in the shoes of that absent parent.
Okay.
That means that that person, he or she fits into that act, and he's entitled to make application solely on that basis. So if you are non-biological parent and you are playing a role in the qualifying child lives, and in this case, we might say that that child has three parents because there is one who is absent, and there is one who is living with the child, and then the third parent will be the non-biological parent.
Okay. That
person clearly is entitled to apply for leave remaining solely on that basis.
Wow, interesting. Thank you very much. I've heard of de facto parent, but then I wasn't really privy to that. But thank you very much for throwing a very good light on de facto parent. So I'm going to stand on de facto parent and ask you a question. So, assuming I'm a de facto parent, what do I need to do in the child's life to demonstrate my responsibilities, obviously to be eligible for the residence permit? What do I need to do? I mean, because I'm a de facto parent, but how would Home Office know that I've stepped into the shoes of the biological father, acting as a biological father, and doing having parental responsibilities towards the child?
Yes, as I said, when I was just elaborating on this, I quoted the case of RK versus the Secretary of State, 2016, which is an upper tribunal case, well-established case, still a good law. It makes it very clear, or it gives clear definition of those who are de facto parents and how that can be adduced or be proven. So let's say, for example, you live with the single parent, which is the woman who has perhaps already made application on the basis that he is a parent of a child who have lived here for continuously for 7 years, and that child is under 18. Or that parent is a mother or a father. And I want to make this distinction here. It's not just lone mothers or single mothers. It applies to fathers as well.
Okay.
So which means that if you had a child with a woman as a father, and that maybe your relationship with that particular mother has broken down irretrievably, and that particular mother has left the relationship, left the child in your care. Sometimes even that parent might have even traveled abroad. That mother might have traveled abroad. And now you are now in a relationship. And I know a lot of people, this message will resonate with a lot of people who are probably watching us tonight or may watch us later when the video goes around. That they are in relationship with fathers who are equally lone parent. So normally, if for example you are that mother of that absent mother, or you are the one in a relationship with the man taking care of that child whose mother has left, traveled to another country, or is even in this country, she couldn't even bother to even look after the child, and is not playing that role, then the point is that if, for example, you are the one that takes the child to school or collect the child from school, or for example, if the child is going for appointment with the father or the mother, you accompanies the child with the other parent, or for example, you guys go to check together. So normally, maybe when there are issues, social services have been involved, they are aware of your presence. So it means that you can get evidence from these sources to show that you are the one playing that role. But more importantly, that parent, lone parent, can even confirm in writing that you are the de facto parent. And that in itself is sufficient evidence to demonstrate that you are a de facto parent.
All right, thank you, lawyer. So, this area is very particular. It's very important to me because I've got a lot of friends. I've got a lot of people who are in similar situations. So, I've got more questions for you. I mean, I'll be hitting on a couple of things that you've mentioned, and I'll be relying on your submission to ask you more questions. So, talking about de facto parent, if you are living with the child, must there be any form of relationship between you and the child's mother? Should there be any sort of intimate relationship before you can be qualified as a de facto parent? Or you could be just like an uncle, or maybe even a tenant living with them or whatever, but you have some sort of responsibility in the child's life to be that de facto parent.
Oh, MC Chaka, you are so intelligent. Thank you for this wonderful question. In fact, I would have forgotten about it if you didn't ask a question like this. You know, it shows you are well learned. Now, the point is that, and I'm sure people who are listening, some people may be jubilating that, oh, I'm an uncle. It means that I can also claim de facto parent. I must say that when you look at the case of RK versus the Secretary of State, the case that I have relied on continuously in this discussion, when you give the definition of de facto parent or the non-biological parent who are entitled to apply, it excludes certain people's like carers. If you're a carer, you are not entitled. Though you are non-biological parent, you are not entitled. If you're a family member, for example, uncle, grandparent. In fact, the case of RK was about a grandmother from India who wanted to rely on the fact that one of the parents he was a paternal grandmother. He wanted to rely on the fact that one of them was sick. He had mental problems, so he could not take it up. So he had stepped into the shoes of that particular parent who was sick and wanted to claim, rely on de facto parenthood, or rely on the fact that he's a de facto parent in order to regularize her stay. And the court decision was quite clear that because of the fact that he was a family member, he's not entitled to regularize her stays on that basis.
Okay.
So in that decision, the court defined de facto parents to exclude grandmothers or grandparents, carers, family members, because those family members obviously would have played a role in the child's life anyway. Okay. So it doesn't permit them
to be a father or parent of the child.
That's right, to be de facto parents. But for example, those who are in a relationship with a parent, they are clearly non-biological parents who can also apply.
Well, interesting. That's fine. Thank you very much. So, I mean, even though they don't have intimate relationship with the child parent who is living with the child, it could be that obviously they've got some sort of involvement. It shouldn't be intimacy, but it could be any other. Rather than having a relationship with the child, they could still be eligible.
Yes, as I've said, those who are excluded are the family members of the child. So let's say grandparents, uncles, carers. In that case, it was well established. So it clearly suggests that if you are in a relationship with the parent, let's say you are the boyfriend or the girlfriend of either of these parents who have left the child, then of course you will step into the shoes of that absent parent. And the other point that I also have to make it clear is that you cannot claim de facto parent as a grounds for making this application. When the two parents, they might be living apart, but as long as all the two are playing role in the child's life, then that third person who is not biological parent cannot. So I must warn people. Let's say, for example, in a case where that's why we started the discussion by looking at lone parents making application, two parents making application. Let's say two parents have made application on the basis or relying on the same child. and they have been granted under Gen 1.10 or 1.11, which is normally Appendix FM outside immigration rules, then if you get into that relationship with the mother or the father
afterwards,
relying on the same grounds
child.
as the same child to make application, then this application is likely to be refused because so it is only when one of the parents is not playing a role in the child's life, then you can step into the shoes of that parent who is not playing a role in the child's life as a non-biological parent to make application.
Lawyer, I've got a question. Let me hint you here with that. So, assuming I was in a relationship with a mother, and through that, maybe it's my child being in a relationship with the mother. Through that, we've both got our, permit, resident permit, and I've moved on. Okay, so my involvement or my responsibility towards the child no longer exists. Okay, so the mom has now become single, living with the child. I'm no longer involved in the child's life. So if you ask me social services or benefit, universal credit will confirm that this mother is a lone mother, and the mother meets somebody outside. Okay, and that person steps in, comes to live with them, and start taking responsibilities that I negated. Can that person be eligible? I'm no longer involved in the child's life. Can the person be eligible to claim these, de facto, on the basis of de facto parent?
Well, thank you. It's good that you are asking very relevant questions for viewers to understand what we are discussing. Now, let me just answer this question by looking at scenarios because it makes issues very simplistic for viewers. Now, if, for example, a child was born to a father who is British or has a certain status. Now, that child maybe the father has supported the child's application for the child to be granted or to be issued a British passport. Perhaps that biological father is in a relationship or is married. He doesn't even want the wife to know that he has given birth to a child outside the marriage. He doesn't want to be involved with the child. In fact, the only thing he did is just supporting the application to get a British passport for the child. So under those circumstances, that particular father, save having supported the application for the child to get a British passport, she doesn't play any role at all whatsoever. She's not paying child maintenance. She's not playing any role at all. Under those circumstances, that father is absent in the child's life. So that mother who is a lone parent then gets into relationship with another man. That man then takes the responsibility or the responsibilities of the absent father. Then it means that that particular non-biological parent has become a de facto parent.
Okay.
In the same vein, if a child was brought from abroad, obviously under the age of 18 years, has lived here for 7 years, and at the date of making that application, that child was still under 18, that particular parent who brought this child from abroad then forms a relationship with another person. The father, probably in Ghana or Nigeria, has never played any role in that child's life ever since the child came abroad. So that new person who is involved in the child's life by having an association with the mother has then become a de facto parent. So the conditions which was established in that case is that the other father or the other parent, being it a mother or father, should not be playing a role in the child's life. And therefore, once that parent, biological parent, is absent, then the other parent who have then come into the relationship and playing a role with the child becomes a de facto parent.
Great. That's very interesting. Thank you very much, lawyer. I know you've taken your time to explain this. Viewers, this is very important topic. It's very sensitive area. Now, after the Brexit, a lot of people that I know a lot of people personally, that they're having issues to regularize their stay, to get whatever they need to get in this country. So it's been very necessary for lawyers to explore and to find other areas to help people with their immigration matters. So viewers, please, this is very important. Make sure you tell your friends, you tell your family who are in the UK, who are non-resident, who are sort of trying to be resident, to obviously rely on this if they are in that circumstances. Because I know a lot of people living with partners that obviously they think they will not be eligible to apply as a de facto parent. But lawyer has given us a very good overview of what a de facto parent is, what a lone parent is, and both parents living under with a child after 7 years born in the UK, and even 10 years to get their stay. It's been very insightful, very informative. But then, to continue, let me acknowledge my viewers. This is very important to me. This is what I do all the time, and it's exciting. And we really appreciate you all to be watching us whilst we educate members of the public, whilst we bring this to you. So, Karen Asari Smith, Karen, thank you very much for watching. Nana Poku Patterson, Ura has got a fire store up in the air. Sagacious Saga. Great program. Thank you. I like your name, Sagacious Saga. Thank you very much. The de facto parent discussion right now is getting very sagacious. I like your name. Okay. So Awo Dede, well done, MCNA. Thank you very much, Awo. Nana Poku Patterson is saying big ups. Jane Opoku, God bless you for your time. Thank you very much, Jane. God bless you too for watching. Hey, Kenneth Ayiba, our mate from Legon, V-mate. Kenji is watching, saying, nice one, bro. Nice one. Mame Ajua Jomo is watching. Thank you very much, Majua, for watching this program. So, viewers, we've got a couple of questions. We're going to switch to another areas that obviously we can apply or make applications for that. Before that, let me take a short commercial break because I know lawyer needs to drink some water and continue. We're going to go over the time just a bit, but please tune in, don't go away. I'll be back, and when I come back, the phone lines will be open as well, and you can ask lawyer any question of your choice. So please stay tuned. MC Chaka and lawyer will be back in a bit. Thank you very much. Welcome back, viewers. So we're talking about how a non-biological parent qualify for leave to remain after 7 years of a child resident in the UK. So lawyer has given an overview talking about lone parents, their eligibility, or how they can make the application. Two parents, both parents, how they can do it. Benefit for children who is over 10 years that the parent did not even do it. How non-biological parents can still qualify to remain, obviously, under this. And he mentioned the de facto parent, which he has given a very good briefing or overview on that. I'm going to move on to the EU. We know after the Brexit, the EU applications have been very, for some reasons, disturbing. People don't know their right. They don't know how their eligibility lies. So under these circumstances, we need to view the VU as to whether people will be eligible. So what about children with pre-settled status under the settlement scheme, which is the new EU scheme that has been introduced? Whether lone parent or both parent, biological parent, how can they equally qualify for the leave to remain or for the permit under the EU settlement scheme? I hope you understood my question clearly.
Clearly.
That's good.
Well,
please go ahead.
Thank you. The point is that I'm sure people are familiar that when we exited the European Union, they introduced the settlement scheme for people who have residence cards, permanent residence cards, and EU citizens themselves and their family members to register and apply for the settlement scheme. So most of them by now would have been granted either settled status or pre-settled status. And if you are one of them who hasn't still made that application, it is still open. You have to make that application. Obviously, you need to provide the reason why you didn't do it earlier. But you can still do those applications anyway.
Okay.
But the point is that if you look clearly, the EU nationals have been included in the Appendix FM. So in this case, if, for example, you are an EU national who has pre-settled status and you form a relationship after December 2020, then you could still make application on that Appendix FM. In the same vein, children who have been granted pre-settled status as EU nationals also form part of the qualifying child definition that I've just elaborated.
Okay.
It means that, let's say, for example, you form the relationship with an EU national, you made application, the application, for example, was refused because maybe they alleged that it was a marriage of convenience, maybe you attended an interview, the interview was unsuccessful, and then the application was subsequently refused and you've lost all rights of appeal. If that particular EU national has children who have been granted pre-settled status and you are still in relationship with that particular person, be it a woman or a man, then irrespective of the fact that your previous relationship was adjudged that of convenience, if you can prove that you have a genuine and subsistent relationship with that EU child who has been granted pre-settled status, then everything I have discussed today applies to you.
Oh, okay.
It means that those people are equally entitled to make application on the basis of that qualifying child. And in fact, I have a client that I'm dealing with, and I'm sure he's probably listening. It's good news for him.
Okay.
So some people were granted residence card. Maybe one reason or other, the relationship broke down. They couldn't adduce evidence, and eventually they have a relationship with other EU citizens. Maybe they couldn't make application. All these people have grounds for making applications on the basis that they are in a relationship with a EU citizen who has a child. And for example, most of these EU people may have migrated here. They are living here with their children. They are living in a house with a man. And maybe the father is still in another member state. He has not bothered to even ask after that child. That particular person, man or woman, living with that lone parent in that house, in a relationship with that person, is entitled to make application under the Appendix FM on the same basis that he or she has a genuine and subsistent relationship with that child who has been granted pre-settled status as an EU citizen.
Okay. So, lawyer, let me quote you on what you said, under the Appendix FM. So that means that obviously it will not come under the EU law, but then this time around under the UK, immigration laws.
Yes.
And then they still be eligible to be a de facto parent.
That's right.
Or whether they are the actual parent, or even if it's a lone mother or lone father.
Yes.
Okay, that's great. So, this is up to us. This is very insightful, very informative. And we all know a lot of questions that we've been getting. Please, I don't want to leave here and people start calling me that, MC Chaka. So after the EU, what is going on? This is, the lawyer has hit the nail right on the head. So please make sure that for all your immigration matters, for all your legal matters, look no further. Contact lawyer Thomas Beyebenwo from City Law Solicitors. City Law Solicitors are located at Unit 113 Barking Enterprise Center, 50 Cambridge Road, Barking. And their postcode is IG118FJ. If you want to contact them, the office number is 020 33 550782. I repeat, it's 020 33 550782. So, EU parents, EU de facto parents can still be eligible, they can make application under the Appendix FM. This is a very good news for us. So please, if you need any of these information, or if you want to resolve your immigration matters under any circumstances, somebody is trying to call us. Caller, the phone lines are not open yet. Hold on one second. Let me give you benefit of that. See. Hello. Oh, we've lost the caller. I'll open the phone lines very soon, please. So, I want lawyer to finish giving the summary on every aspect of the topic, and then be able to open the phone lines. Please bear with us. So, lawyer, let me move on. Thank you very much for throwing light on that. I'm very excited tonight because I will have some good, response for my people that contact me all the time for this kind of information. What about those above 18 years, but less than 15 years, who have lived half of their life in the UK? Okay. Can they be eligible to make any application at all?
Yes, I think this is just an update. Anybody who has lived half of their life in the UK, and obviously that person is between the ages of 18 and 25. Because normally, under the private life, if a child, as a qualifying child, as I explained, if a child came to the UK from abroad and lived here for 7 years, and that child is under 18 years, that child is entitled to make application for limited leave to remain unarticulate under private life. So, in the same vein, if a child is above 18 but under 25 and have lived here for half of their life, those children are entitled to apply for limited leave to remain, also under the 10-year route. Most of these applications are under the 10-year route.
Oh, okay, the 10-year route.
So I think on the 25th of October, there was a statement of changes to say that if those children have lived here and they are under that route, 10-year route, because of the fact that they fall within the category of above 18 but below 25, and they have already had subsequent renewals 2 and 5 years into that, they are now eligible to apply for indefinite leave to remain, even though that is at discretion. They need to prove why they need it. Yes. Okay. So that's a statement of changes that the Home Office have just introduced. Good news for all those, because I have a client that I've been dealing with. It's a good news for him because I've renewed them. I remember that family, when they came to me, they were not even aware. That's why I always entreat people to share these videos. Yep. When they came to me, MC, that child was 1 week less of 18 years. Wow. And they have been around, they've made numerous frivolous applications, spent numerous, in fact, huge sums of money, wasting money on things that
necessary
are not sustainable. Yeah. So somebody out of sheer luck brought them to our office and made application the following day. And the mother and that child were granted limited leave to remain. Now, this is the second time he has it. So this is a good news for one of my clients. So if you're ever listening and any of your family members fall in this category, it's good news. They can now apply for indefinite leave to remain.
Viewers, I must say that it's not coincidence that you're watching this program, and it's not coincidence that we've got Lawyer Thomas, obviously, to throw light on this legal aspect of law. Lawyer, thank you very much. I'm going to put last question to you before I open the phone lines. I know time is fast spent. So what about British lone parents living abroad? Can they equally apply to come to the UK? If you're a lone parent, you've got a British child, lone parent abroad, can you equally apply and come to the UK?
Yes, that's a good question. A lot of people are probably not aware of this. But remember, we have dealt with one of the topics about how someone can apply for a passport for the child born abroad without the support of the British parent. So if somebody ever went to, for example, Ghana, Nigeria, Sierra Leone, or any part of the world, even America, and give birth to a child there, and there is element of domestic violence, and that person is reluctant to support that application for that child to be issued British passport, that parent can do it solely on that basis. And we have had discussion on this platform about that. So I'm not going to revisit it. But the point is that if that parent has a British passport for that child who is now living abroad, then again, that parent is entitled to make application to come to the UK solely on that basis of that child, that British child. However, under those circumstances, that parent needs to satisfy the maintenance requirement and accommodation requirement to be sure that when he migrates to the UK, he will not be a burden on the state.
All right, lawyer. So viewers, the phone lines are open. Please make sure you call. The number is at the bottom of the screen. The number to call, the studio line, is 079 3293 4518. 079 3293 4518. The other line is 0744 033 8623. 0744 033 8623. Please make sure you call now, because City Law solicitors, they are our immigration Jesus. They've come to support us. They've come to alleviate us from every hardship that we're going through. They specialize in all aspects of laws. Let me say hi to my brother Leboko at Accra. Leboko is watching us live. Lebo, thank you very much for watching. And then also to you, our Facebook viewers that have joined us now. Aiba Kenneth, Jane Opoku, Karen Asare. And I've been updated that a couple of people are listening to this program through the radio as well. Commander Lexus, all the way from America. Commander, thank you very much. VMate, Chief Commander, Chief, thank you very much for listening to this program. So viewers, we wait on your calls. Please call, because this is very important topic that the lawyer has explored tonight. We've covered so many areas of de facto parent, lone parent making application in the UK, both parents making for a child under 7 years old, and obviously 10 years old if they were not sure of that. There's a lot of areas that has been explored. I've learned a lot tonight, and I believe you all have. So please make sure you call. The phone line once again is I think someone is calling. Yeah, we've got a caller on the line. Hello, good evening. My name is MC Chaka. Who am I speaking to? Hello, can you? Hello? Hello? Yeah, please, can you either move away from your Facebook?
Hello?
Yeah, I can hear you clearly now. Hello. My name is MC Chaka.
Yeah, MC, can you hear me now?
Very loud and clear. Who am I speaking to, please? And where are you calling from?
I'm calling from Telford, Awodede speaking.
Oh, hello, my dear sister Awodede. How are you, Awo?
I'm good. How are you?
I'm doing very well. Thank you very much for watching, and thank you for calling. How can we help you this evening?
I think I got lost when lawyer was talking about those 18 or 20 years, about the indefinite leave to remain, that if they are on the 10-year route and they've renewed maybe twice, they qualify for indefinite. So I wanted to verify or clarify if it's for only the 18 years or below 18, like 10 years, and you renew your permit twice, you still qualify for that. as well, indefinite.
Okay, lawyer, the ball is in your court, please.
Thank you. Yes, it's quite clear when there are two categories for children to make applications. They have the first category of children are those who are under 18, which is what I have defined as qualifying children.
Yeah.
So there are those who are also above 18, but below 25.
Okay.
So you realize that from what I've defined, a child could start from the 7-year age group, when that child came into the UK. Let's say a child came from Nigeria, for example. That child came here at the age of 10. That child would have turned 17 to get the first limited leave to remain. Now, when that child gets the first limited leave to remain, that child obviously is going to be on the 10-year route. So when the child applies for first limited leave to remain, which is 2.5, that child will be 19.5 by the time the first limited leave to remain has expired.
Okay.
So from 19.5, she will then apply for another 2.5. So that makes that child 22 by the time the second 2.5 expires. That child would have been on that route for 5 years. Now the route is normally for 10 years to indefinitely to remain. But that child, because of the fact that he's now within 18 and 25, under the new rules, that child is entitled to apply for indefinite leave to remain. I hope this makes it clear for you. So the child needs to have been between 18 and 25 and needs to have been on the leave for at least 5 years. So instead of waiting for 10 years to get indefinite leave to remain, which would have made a child roughly from what I've calculated, maybe about the age of 27 before he gets indefinite leave to remain, that child can now get indefinite leave to remain at the age of 22. Does it make it clear to you now?
Hello, Sita. Hello.
I think you can listen.
Hello.
Yeah.
Yeah. So, has your question been answered?
It has, but I think my question is more of the little ones. Like this child had the first permit when he was, I think, 2.5 years. Although he was not born in UK, he was born in Ghana. But when he came, the mother was pregnant and gave birth to a British child. And through that British child, the mother got her first resident permit when the first one was 2.5 years already.
Okay.
So when the mother was applying, she joined the firstborn one. So by the time he was 2.5 years, he got his first permit. Now he's 10 years. He's got the third one in the 10-year route. That means he's left with only 1 year. That's my question. Does the child qualify to have indefinite now? At the moment, he's 9 years in the UK, but not 10 years.
Okay.
But he started his, resident permit earlier. Like 2.5. I don't know if my question is clear.
Yes, that's quite the statement of changes only affect those who are between the age of 18 and 25 and have been on the route for at least 5 years. So that child, the reason I think the main purpose for this is because some children will be going to the university, and because of these restrictions, they will have issues with
applying for the
public fund and all that. So that is why they've made it in such a way that if you are within the age of 18 and 25 and you have been on that leave for 5 years before you turn 25, then of course you can apply for the indefinite leave to remain. So this child is still very, very young, and she could still be on that leave for the 10-year route. Is it answered now?
Yeah.
Okay.
Yeah. Thank you, lawyer.
I will thank you very much for watching and listening all the time. Thank you very much. So feel free to call anytime that you need any advice on immigration. Okay.
Okay.
Thank you very much. All right. Okay. So viewers and listeners, phone lines are still opening. You can still call. Lawyer is ready to answer your question. Every immigration question that you've got at all. Forget about it. Today's topic. Any immigration question that you've got, please contact us. And bear with me. Hello, good evening. MC Chaka here. Who am I speaking to?
Good evening, Mr. Mark.
Hello, Mr. Mark. Where are you calling from?
I'm calling from Telford.
Oh, Telford, Mr. Mark. All right, thank you very much for calling. How can we help you tonight?
Okay, I want to speak in my local language because I want to communicate better with the question.
That's fine.
Okay, the question is, my will be. I need paper, and I'm able to make paper a mano. Do you hear me?
Yeah, you're talking Kaza. Go on.
And Nipano, me person me paper mano, and I'm a paper mano. It's a fair to tell no more interview, no more say, Yanomia back with you to promote me for my. It's a bit me appeal because the parts of permanent.
Okay. I'm saying, and our question, Chichimu Kakra, Bum Kakra, lawyer.
My mental question, what's the one new binette? What nationality are there? We are EU. Okay, what were any back or no? My application I have from for interview. And I interview we are saying, man, one for your back, continue. Or married near out of convenience. Okay. And I appeal so I go see say or course one answer.
This is no appeal no go so
okay, there so we say. Appeal no is your and also an opportunity for you to prove under probability say relationship no yeah. You know, appeal that here say mobile call before a judge. These days no most of appeal I am mayor office a video to be a other some call.
Okay, as soon as I apply learn apply as and because you are not receiving any
okay. And the here say eventually no ombema directions now mobile to me and na for ni ade bit me atwro for ma so obi bit me atwro say ma ware na ye papa lawyer and I'm sure so nim di oye obesa ni na akoma court ne home office no emre no so am be ma mu date for hearing first na ye ko tribunal ho no mo na bia okura mu a mo ba ko begina outside na ba ko wuro na ye bisa mo questions na the home office lawyer no be bisa questions na obi another one so pii na ba ko no so wuro mse be ya mo mie no obi ante de nyanko ka enti so mo ya sa wie na say in some home office lawyer and baby salmon mo to me prove say ampa mo na mo tibuma the point and say bet me abasa ware bia komo bi wono mo ani na mo koye na mo to me amano ankoye baako because bi wa kwa obe ware na wa woda e bia na ode sie be ma no ana ode sie oba no and so mo office dey hu ne say nkofoko interview na say bia one or two questions you want me answer but mo say oh ware na nje papa
yeah
anything I court to the tribunal no no this is another opportunity say mo kwa mo be make sure say formation bia e farm on mo be hu say the be am be to me prove to judge and say mo relationship na ya genuine why.
Okay, Mr. Baker, thank you very much. I hope say a question has been answered. That's a part. I mean, sure. And this Uyan Chichimu Beyebenwo number now. It was screen is no City Law Solicitor number no. I mean the number is 02033550782. 02033550782. Where your office number now? You can call them and they will be able to help you. Thank you very much for calling. Okay, so viewers and listeners, we're still here. I'd like to say hi to my dear sister Sita from Lagos. Sita is watching us this evening. Thank you very much, Sita, for watching. She just sent me a message. MC Chuck, I'm listening to you on Facebook. I'm watching you on Facebook.
I think somebody has hinted that there are questions under the this thing.
I'm going for
the
it.
Facebook page, so you can.
Okay, today's topic is life changing. I'm not seeing any question, to be honest. Not really. Not really. I've mentioned a couple of people's name. I'm still acknowledging people. Karen is still watching. Mame Ajua Jomo is watching. Kenneth Ayiba is still here. So, phone lines are still open. Mr. Leboko is watching. So please call the number. The studio number is 079 32 93 4518. 079 32 93 4518. And the other one is 0744 033 8623. 0744 033 8623. City Law Solicitors. They are here for all your immigration matters. City Law Solicitors are located Unit 113, Bakken Enterprise Center, 50 Cambridge Road, Bakken, Access IG 118FG. The office number is 02033 550782. City Law Solicitors, their specialty are in areas of immigration law, employment law, family law, personal injuries and clinical negligence, commercial disputes and civil litigations, housing law, consumer law, media and entertainment law. So if you have any issue in all these inquiry or legal areas, please make sure you contact them. If you contact the studio line, and even lawyer Thomas Beyebenwo is not there, his learned colleagues will be there to support you and to resolve your immigration matters. So I've got about 5 more minutes to leave the studio. The phone lines are still open. Lawyer is going to wrap up. If you've got any update or any of the topics, I mean what we printed today, if you want to sort of stress a little bit on it, you've got about 5 minutes to do that, please. If any call comes, we take it. But then phone lines are still open, viewers. So lawyer, over to you. Under 5 minutes.
Thank you. I'm always full of praise for viewers who always come on the platform to support us, to have these laudable discussions. So thank you all for always being there for us. Now tonight, if you have just joined us, we've been discussing how non-biological parents can rely on children or qualifying child, and in that definition we have elaborated on it to the extent that they will include a child either born automatic British, a child who was born here and has lived here for 7 years, or a child who was brought from abroad under the age of 18 and has lived here for 7 years. And we have also included those children who are EU citizens who have been granted pre-settled status. That has also been included under the Appendix FM. So if we look at all these categories of children, and then we also look at the normal ways people make application. If you are a parent of a child who has lived here, or if there are 2 parents of a child who have lived here for 7 years under 18, how you can make application. But most importantly, which is where my passion, if you are somebody who have tried all options, for example, somebody phoning now, their relationship have been adjudged that of convenience. He might have a child and he's living with a child with this wife whom Home Office have categorized the relationship as that of convenience. That person is entitled to make application under the FM on the basis that he has genuine and subsisting relationship with that child. So we've looked at what a de facto parent is, and we found this under the definition, under the case of RK versus the Secretary of State 2016. So we are not just giving fallacies here, we are giving facts supported by the law. So we've learned that a de facto parent can be anybody who have stepped into the shoes of that absent parent. And we've looked at those who are excluded to be categorized as de facto parents as the family members, carers and grandparents and all that. So those people don't fall into the category of de facto parents. So if you're ever living with a mother or a father of a child or a qualifying child, and the other parent is not playing any role in that child's life, and you have stepped into the shoes of that absent parent, then tonight I want you to understand that you are eligible, you qualify, you are entitled to make application on the sole basis that you have a genuine and subsistent relationship with that qualifying child. So that's what we've been discussing tonight. And I'll leave the platform for my learned MC with 3 titles.
Okay, lawyer, I've got a question from one of our viewers. The name is Covenant Grace. I think Covenant Grace has been, following us for quite a long time. So the question is, if a British child faces neglect from both biological parents and child services step in, can a friend step in with confirmation from the biological parents to be a de facto parent? If the de facto shows solely responsibility, can he apply for resident permit? So this is a very, very good question. Thank you very much, Covenant Grace, for your question.
Yes, I like questions of this nature because clearly. Now, if I want to answer this question, this is deep. So remember we looked at parental responsibility, how people can acquire parental responsibility under the family law. Now we've looked at this. We've looked at people who can acquire parental responsibility. And the point is that if you look at Appendix F, those who have parental responsibility are parents or somebody that the court might have given an order. So, for example, if normally under the public law, where social services have stepped in to take the child from the biological parents, and then a family member has stepped in to be able to look after the child because both parents, for one reason or the other, they cannot look after the child, then under the family law, that person has somehow acquired parental responsibility because the court has so made an order. So clearly, that particular person is entitled to also make application. So in fact, this is where, for example, a family member who are excluded as de facto parents may be entitled to also make application because they have at this stage acquired parental responsibility. Remember when I was explaining the case of RK versus the Secretary of the 2016, the reason why that particular grandparent was not able to prove that she is a de facto parent is because of the fact that the father was still living in the house with that grandparent, though the mother was sick mentally and could not look after the children, but the father was still there. So in a case where the father was not there, the mother was not there, then that falls into the situation which Covenant Grace have just asked. And under those bases, that particular person would have succeeded in becoming a de facto parent or having acquired parental responsibility under the family law.
Okay, thank you very much, Lara. There's another question from the same person that, please, can you mention the legal grounds for FLR, that's FP applications, using direct access to British child living with mother?
Okay. Now, when you are looking at the legal grounds for, I've already defined that we have a qualifying child which is defined under the Immigration, Nationality and Asylum Act 2002. Now, when you look at paragraph 276AD, it also gives definition of those parents who, for example, are primary carers or have sole responsibility or have direct access for making application. So you can find this in paragraph 276 ADE, section 1 or subsection 1V of the immigration rules. This is the legal grounds for making your application. And I hope I have answered this question for this particular viewer.
Thank you very much. Now, viewers are coming with a lot of questions. I mean,
it is interesting.
Yeah, very. I'm
like
really loving it. Actually, so viewers, I entreat you all to bring your questions. You can call in the studio line. You can do that on Facebook. You can send it to me directly. My dear sister Mercy is asking a question, saying, Kwame, I'm watching you from my sister's account. What about the adults who are in the 7.5 route? The adults in 7.5 route. What are their rules? Can they apply for the indefinite leave to remain?
I want to be clear about the question. Remember, I said that you said adult. Obviously, when somebody turns 18, that person under the law is an adult. So if when he says 7.5 route, I don't understand. There's always I think 10-year route or 5-year route to indefinite leave.
So in relation to this, I remember that sometime you were talking about the 10-year route, but then you told me that people who maybe after 5 years or whatever will be eligible to apply for the indefinite. But then somebody who is on that same route, say 2.5, but then now the person is 7.5 now.
Okay.
Is there any grounds for the person to obviously get indefinite without going to the 10-year route?
Good. You see, this is the point. The point is that, let's say you've been granted leave as a parent of a British child. Normally, they would have put you on the 10-year route initially. But let's say you've been under the first 2.5 route. You've been on the first 2.5 visa, and you were on it for the expiry of that first 2.5. And then you decided to do the English test, which is the A1 test. And you can also show that you are not a burden on the state, you are working. Normally they expect those people to be working. Then it means that once you are 2.5, first 2.5 have expired, you can then switch to the 5-year route as a parent under the 5-year route. So it means that you will be able to apply for indefinite leave to remain on your 7.5 visa or route. So if anybody is in that category, that person will be entitled or eligible to apply for indefinite leave to remain. However, that particular person need to have switched to the 5-year route. It is not automatic because the 5-year route have distinct requirement which requires candidates or applicants to do an English language test. And for those who are on recourse to public fund, they can't be on the 5-year route because obviously they will always be put on a 10-year route if they are receiving public funds. But anybody who has switched at the end of the 2.5 to the 5-year route, then on the 7.5 year, that person will be eligible to apply for indefinite remain either as a partner or as a parent of a British child.
All right, thank you very much. Mercy or Pokia, I hope your question has been answered. If you need more clarification, please call me, and then I'll let you speak to lawyer. Lawyer, another question from Sita. Does his law firm do conveyancing? Do you guys, City Law, do you do conveyancing?
No, we don't do conveyancing.
Okay, then Sita.
To do with people who want to buy houses.
Okay,
yes.
So Sita, that's fine. Speak to me back door. Lawyer, they don't do conveyancing. So call me, and then obviously we talk about that. But then another question from same person, Sita. I have a question, please. My sister filed for my mom under EU family law. Mom is in the UK now. Can mom file for my brother who is in Ghana once she gets her EU permanent resident?
Okay, if the sister filed for the mother and he's now in the UK, I don't know why he didn't file for the brother as well, because obviously if he was looking after the mother, then perhaps he was the one looking after the sibling as well, so you could have apply for all of them jointly. But I understand maybe she didn't make that application for all of them because after December 2020, it is only parents, children, and grandparents who are eligible to apply for the family permit. So probably that is the reason why she didn't apply for the brother. So in this case, if that mother who has come into this country with the first 6 months and subsequently apply for limited leave to remain or pre-settled status, and eventually acquire settled status, which will then be called indefinite leave to remain, and that particular brother, which is the mother whose mother is now here, who has then got indefinite leave to remain, will be entitled to apply for that child to join her here. But he needs to show what they call sole responsibility, because this will be made under the immigration rules, not under the EU law.
All right, viewers, thank you very much. It's been very interesting. It's been very insightful, very educative. Thank you very much, Lawyer Thomas Beyebenwo, for your time and for the knowledge you've imparted onto us this evening. So, viewers, this is where we draw the curtain. Thank you very much for watching. My name is MC Chaka. I've been your host for this program. Next week, Tuesday at 8:30, we'll bring you the Legal Hour with another educative and insightful topic. So until then, I'll say good night to everyone. If you do have questions, please contact City Law Solicitors on the number that is on the screen, and your all immigration matters will be answered. So thank you very much once again, and you have a pleasant, good evening. Thank you.